Good day. My name is Gerald Goldfarb, your host, and this is the television interview program Inside Law. This is a program where we try to interview prominent and interesting lawyers and judges in the Southern California legal community so that you and the general public can get sort of an inside view on how the legal system really operates. My guest today is a very interesting lawyer in Los Angeles named Dan Stormer. Dan is a partner in the law firm of Litt & Stormer in Los Angeles, and he specializes in what lawyers call civil liberties law. And he's really a unique lawyer and a man whose practice I very much admire. After graduating law school in the early 70s, a lot of lawyers were lining up to get into big law firms and try to earn big money. Dan went instead to work for Legal Aid and learned how to be a practical lawyer, handling the problems of sort of the downtrodden in our community. And now, of course, he's a partner in his own law firm and still has that sort of practice, but from a somewhat different point of view. So, Dan, welcome to our show today.
Thank you.
I'm interested to know in general, you've practiced in the field of civil liberties law for quite a while now. Overall, has there been progress or change in the field? Has it been going backwards during the Reagan years? How do things stand?
Well, it's changed. I don't believe that it's going backward, but I believe there have been attempts to push it backward. As you and I have talked in the past, some of the changes, some of the attempts both within the state and within the Reagan administration there have been attempts to do damage to certain civil liberties.
We hear about Edwin Meese being a problem for civil libertarians. Do you think that's really true?
Oh, absolutely. I think that if Edwin Meese had his way, the Bill of Rights in the United States Constitution would look radically different. This is the man who called the ACLU, the American Civil Liberties Union, a criminal lobby. He's a man who has shown little, if any, respect for the rights of individuals.
How about in California? How is the environment for civil liberties law in California?
Well, California has a sort of populist approach to civil liberties and traditionally has been very supportive. I think in recent years, primarily as a backlash to criminal issues, there have been some what I think are very bad issues developing on things which concern us all. One of the examples that I have used in the past is the issue of the roadside stops for drunk driving. Now,
that was just approved recently, wasn't it, by the courts?
The state Supreme Court approved a procedure by which people who are absolutely not under suspicion for doing anything other than driving can be stopped and be at risk of arrest and prosecution and jail simply because they're on the highways. And that's the sole reason. There really doesn't need to be any other reason. And the U.S. Supreme Court has...
So the police can just pull over any car that they like under these rules?
Actually, no, under these rules, it has to be a checkpoint, and basically you have to stop everyone.
I see.
Or you have to stop everyone who fits a certain profile. Mm-hmm. The reality is that what it means is citizens, irrespective of whether they are showing any signs of being under the influence, can be stopped and subjected to arrest. Mm-hmm. And in traditional constitutional analysis, this would never be allowed. The only time it's ever been allowed in prior legal history have been in areas around borders where there's a high likelihood that people in that area might be unlawfully entering the country.
But these stops for driving under the influence, they've kind of been justified on the basis that we have an emergency, a drunk driving emergency. Isn't that true? And don't we have to do something about it, especially at holiday time?
I agree something has to be done. I never agree that an abridgment of fundamental rights is the way of dealing with it. A person would have to be crazy not to recognize that this is a significant societal problem. But there are substantially better ways of dealing with it. I'm certainly not an expert of the better ways of dealing with it, but I am an expert in what is constitutionally permissible.
How about the battering ram that I read not too long ago that were being used against drug dealers, rock houses? That seems like a civil liberties issue if a battering ram rolls over your house.
Well, interestingly, that case went before the state Supreme Court, and the battering ram procedure, which had been used by the LAPD, was found to be unlawful. And interestingly, the position that the LAPD has taken, that they check everything out and they're absolutely certain that this is absolutely essential in the particular instance, was belied by the very first time they used it, when they crashed into the wrong house and almost killed an 11-year-old sitting at the sitting in the living room. They showed absolutely no interest in the protecting of the individuals. And basically what they determined, it was a poor neighborhood. There may well be drug dealers in the neighborhood. It looked like this might be the house. They didn't really do anything more, and they just broke down the door, and it was the wrong place.
And did they crush the house, actually knock down the walls?
Oh, yes.
The government ever paid these people back?
Actually, there's a lawsuit pending, which the American Civil Liberties Union is suing the LAPD.
To get the value of the house that was crushed. Well, that's interesting.
But that's an area in which society says, well, we have a drug problem. And we have to deal with it in some way, rather than dealing with it in the way that societies might find, well, rather than dealing with it in a way that deals with the constitutional problems, they choose to abridge the rights, to engage in dramatic displays of firepower and weaponry and brute force, rather than do something that might be more subtle but ultimately more effective.
I see. Well, nonetheless, you think that civil liberties are being reasonably well protected in our culture today?
I think civil liberties in the last 20 years have sort of moved up the hierarchy of what is acceptable. Nobody in our society who isn't a recent Reagan Supreme Court nominee, who I'm referring to Bork, could find many of the proposals of the far right acceptable in the civil liberties sense. The caveats on sales of homes for either racial or religious reasons are totally unacceptable. Racial segregation is unacceptable. There's a whole area in which things are just not accepted, even by those people who traditionally would not have accepted it.
That's interesting, Dan. Let's talk about some of the specific cases you handle that I think illustrate the condition of civil liberties today. Now, I know that you were very active in defending groups of Palestinians that the government was seeking, I believe, to either incarcerate or evict from the country. Give us a little information on that case.
That is a classic example of the different approach that is being used by the Reagan administration, and in this case, particularly the Department of Justice. My clients are 7 Palestinians and 1 Kenyan woman. They were arrested in January of this year, supposedly because they violated certain statutes involving the immigration laws. The statutes were remnants of the McCarthy era. In fact, the 2 statutes that they were prosecuted under were both created in the height of McCarthyism, in the height of anti-foreigners, in the height of the craziness that went on in the early 50s. But were so egregious that they had never even been used by prior administrations ever.
And they were used against these Palestinians?
And they were used against these Palestinians.
Well, they were part of a larger group of Palestinians, weren't they?
No, they were... what it was in this case is we discovered very early on in the case, as a result of someone who leaked information from the bowels of the Department of Justice, that the Reagan administration had created this plan. And this plan was a plan to round up as many as 5,000 Arabs and put them in a camp. In the camp was Oakdale, Louisiana. At that point, Oakdale had not
before the Cuban
before
prison.
the Cuban
right.
prison uprising.
So wait, I want to see if I understand this. The government, the United States federal government, had a plan to round up 5,000 Palestinians. Well, why were they going to round these people up?
The plan called for revoking all visas and arresting all these people, and they ranked them in three categories: alien undesirables, alien activists, and alien terrorists. The first two would be people who hadn't done anything unlawful, who hadn't done anything that was in violation of deportation statutes, but they just didn't want. And the second was basically a group that they wanted to move against to limit the agenda on behalf of the Arab people that is developing in the United States. That is a response to what's going on in the Middle East.
And what did you as a lawyer do to prevent this plan from being implemented?
Well, actually, we as lawyers didn't do anything vis-a-vis the plan other than bring it to light.
They started with your clients.
They started with our clients, and in this process of the litigation, we discovered this plan and released this plan to the press. And it was an interesting thing because the people who read about this plan, we would get just literally hundreds of calls, became enraged. And it was an interesting process because the press very much picked up on this, and the press reports became more and more sympathetic to what was happening to our clients and more anti-plan. When initially they had it was an interesting thing to watch because when our clients were arrested, there was a big screamer headline in one of the local papers: "War on Terrorism hits L.A." After the FBI admitted that they had surveilled our clients for 3.5 years, that they had bugged their phones and had people living next door, the head of the local underground unit living next door.
For years.
The person lived next door to them for 6 months, but they had been surveilling them for 3.5 years, and they couldn't come up with a single instance of illegal conduct. When William Webster in his confirmation hearings admitted that if these people were American citizens, they would not be in the situation they were presently. And when it became clear that this plan was being implemented, people reacted. There was an amazing outpouring of support for our clients. And in one of the hearings, it was a fairly dramatic hearing, the government announced that they were dismissing charges against 6 of them. The McCarran-Walter charges, the sort of the claims that they were involved in some sort of bad activity, and as the reason to the court, in an open court, gave that they never expected the adverse public response to what they were doing.
It really shows how they're out of touch with what the values of the American people are. Tell me a little bit also, another case that I'm interested in is the Lopez versus Heckler case, in which, again, the government seems to me to have been planning to take unpleasant action against a large number of people, thousands of Americans, and the legal system was able to intervene and prevent it.
Well, that case was another example of the Reagan agenda. In that case, it arose out of budget hearings in the early 80s. And the Reagan administration proposed a $3.2 billion cut in Social Security, which Congress immediately rejected. It was actually the first setback that Reagan had. This was in '82. The following fall, in their budget analysis submitted by the OMB, the Office of Budget Management, the Reagan administration said that they were going to save $3.2 billion by cutting off people who shouldn't be on Social Security rolls. And they began this massive process of cutting people off who were totally legally on Social Security. And they adopted this legal procedure, this procedure which chose to go to review literally tens of thousands, literally hundreds of thousands of people, and knock them off the rolls if they didn't meet certain criteria that the Reagan administration had created, not that were within the statutes.
Well, would they interview these people in person and give them some evaluation, or is this all by computer?
All by either computer or by a review of the records. And what happened was some of these cases were appealed, and the Ninth Circuit, the circuit that covers the 9 West Coast states, found that the Reagan administration was acting unlawfully.
And what was the result? Did these 70,000 odd people, did they get knocked off the rolls?
Yes. Well, the Ninth Circuit, the appellate court ruled that they couldn't do this, and they said, we don't have to abide by the Ninth Circuit because we are a national agency, and the national agency isn't bound by one of now 11 circuits. And
so they declined to follow the law.
They declined to follow the law.
Did they get away with it?
No, they didn't. We filed a lawsuit, and Judge Gray, the local federal court judge, certified a class. That is, he said all these 70,000 people could be represented in one single lawsuit. And the day of the hearing, he basically unloaded on the government and called what they were doing bureaucratic arrogance, and in his written opinion noted that people had died as a result of this refusal to follow the law.
Wow, that's very interesting. So it's another instance really in which the law was used to benefit a large number of people who really were downtrodden people and needed some help. What about, I understand you've also had lawsuits in the field of handicapped law. That's an area that's boomed. That's not the right word, but it's an area that's grown in recent years.
Well, traditionally, you were basically allowed to discriminate against people simply because they couldn't walk or couldn't see or couldn't hear as well as other people. And the area of handicap discrimination is an area that's law created as opposed to created under some constitutional theory. And in recent years, people have started to say, well, just simply because a person can't walk up a step doesn't mean he or she can't do the job. And recently, for instance, we sued the city of Los Angeles because the airport at Van Nuys was really totally inaccessible to a person in a handicap, a person who was in a wheelchair. And our client was a person who modifies aircraft, a professional flyer or a businessman. But he couldn't even get to some of the places on the airport that he had to get to in order to conduct his business. And we ultimately resolved the case, in 18 buildings, including a restaurant and a hotel, have to be altered. But one of the things that struck me during the course of litigation is one of the attorneys that opposed us at one point said, and I was absolutely amazed by this, he said, so what you're telling us is that you want this whole airport to be accessible to somebody who's in a wheelchair. And I said, yes. That's exactly.
He had to have his consciousness altered a little bit, didn't he?
So you start out in those cases, you start out with a prejudice against your client that would be totally unacceptable in other areas like race or sex, which we also do a lot of litigation in. But people who would just blanch at the concept of saying, well, you want it totally accessible to all women, will say something like, be angry because you want it totally accessible to people in a wheelchair. So that is an area where a lot of litigation is taking place because people really have a particular prejudice or bias against those within our society who are physically different.
And we also have problems in our society with people who are morally or emotionally different and have different political views. I'm thinking of the David Waite case. He was different. He didn't want to go along with the program. He, if I remember correctly, refused to register for the draft and was prosecuted. And again, he's a representative of a large number of people. What happened in that case?
Well, David actually was a case where we won by losing. In David's case, it was when the situation in Iran erupted, President Carter issued a presidential resolution saying that all persons between the ages of 18 and 26 had to register and gave certain dates. David at that time refused to register. He felt that morally he could not register for the draft. which was a step before the draft resistors of the 60s and 70s, because those were people who had registered for the draft but refused to report when they were called up. He refused to even register. And that was a case in which there was an incredible outpouring of support for David. We took the case and litigated it here in LA and won. And we got the prosecution against David dismissed. The government appealed it to the Ninth Circuit, where it was reversed, and then went up to the U.S. Supreme Court, where they agreed that David could be prosecuted. The interesting aspect of that, though, was that we litigated that case heavily. We also worked on a couple of the other cases around the country. And the result was that the outpour of anger against what the government was doing was so substantial that in the 4 or so years that this process has been going on, there have only been 18 prosecutions, and there are, at last estimates, between 500 and 700,000 people who have refused to register.
I see. So this sort of litigation prevented the government, you think, from pushing against those hundreds of thousands of people?
Oh, absolutely. What it became clear was that for every case there was going to be a fight, and for every fight the government's position on this would be exposed once again as being unpopular. So what they've chosen to do is just go away. They stay with the draft registration program because now to do it would basically be looking at backing down from their agenda, but they can't do it because the American people basically became outraged at the prior prosecutions.
And but David Wade himself was actually convicted and sentenced, wasn't he?
Yes, David was sentenced, and he was sentenced to 6 months at his grandmother's house.
Well, that wasn't too bad. All depends on his grandmother, I guess.
Well, it does. Judge, it was an interesting decision and a very gutsy decision on the federal judge's part, Judge Hatter. What he said was, but it also indicated his inclination to recognize that there had to be something done. He said, of course, sending David to prison was just stupid, because David was an exemplary citizen, a high school athlete, a high school scholar. He'd gone to Yale, he'd done well at Yale. He just didn't want to register for the draft. He wasn't committing unlawful acts, so sending him to jail wasn't a good thing. He didn't want to send him to do volunteer work, because that's what David did. I mean, at that point he was volunteering in a handicapped, at a development disabled facility, and that's the type of work he did. Well, so he said there had to be a punishment, and the punishment is your house. You're confined to your house, to your grandmother's house, which is where he was living, for 6 months.
Well, this is sounds like a very reasonable judge, Dan. And that's an interesting case, and I know you handle a lot of other interesting cases that maybe we won't even have time to get to today. I know you handle cases involving sexual harassment, and I know you handle slumlord litigation cases in which people are being taken advantage of by landlords who don't follow the rules. But what I'd really like to know a little more about as a practicing lawyer is handling all these cases for various sorts of disadvantaged and downtrodden people. How do you make a living at it?
Actually, we make a very comfortable living. We don't make a living that is going to get us on the list of the 10 wealthiest people in Echo Park. But it is going to be a comfortable living.
Where do your fees come from?
And the way we make it is basically by filing these cases on what are called fee-shifting statutes. The way this works is you sue the opposing party. It's often the government. And if you win, then they have to pay your attorney's fees. But first you have to win, then you have to submit an application to the court for attorney's fees. And we've been doing it sufficiently to grow to, as of the beginning of January, we'll have 12 attorneys in our office. And we just started about 4 years ago. So it's been a very successful practice, and we've been able to earn a living.
So that you can earn a living representing poor people, and not only representing corporations.
Absolutely.
Well, what's the biggest fee your firm ever got? Can you tell us that? There are real big fees in your field in general. I know. I've seen some in the lawyer's newspaper.
The biggest attorney's fees award, I guess. I'm trying to think. I think about $200,000.
$200,000 for one case.
For one case.
That's a nice fee. That can pay a lot of overhead and buy a lot of library books.
That's right.
That's great. I guess it's an example for young law students, perhaps, or people to realize that they can. There's a lot of choices and a lot of possibilities in the law.
Well, there are. I mean, it's amazing because we're one of the very few public interest firms who are private. We get literally hundreds of job applications from people who want to do this.
Idealistic young lawyers.
Yeah, this sort of yuppie syndrome, which is being painted by the press, I don't think is being reflected by the nature of the lawyers who are coming to us looking for work, and they're lawyers who are not people who are disdainful of school. They're people who were cum laude from their college or magna or summa cum laude from their college, went to law school, and were law review. And they're people who are just being sought after by large firms, but really have a commitment to poor people's issues. So I don't see, it's not reflected, at least in the people that are applying to us, that there's any lessening of interest in this.
Well, it's good to know that idealism is still alive in the legal system. Dan, I want to thank you very much for coming on the program today. It's interesting to talk to you. It's interesting for me to learn some of the things that are happening in the legal system, and I want to thank our audience for being with us today. I think Dan Stormer is a kind of lawyer that shows the legal system at its best. He's working, as we heard when we discussed some of his cases, he works to preserve the rights and the liberties of aliens, of handicapped people, slum residents, dissenters, sexually harassed people, all sorts of people who in other countries and other cultures might have a very hard time of it and have a hard time of it here too. So he's doing all those things, and he's actually making a living at it, which is a great thing, and all the lawyers and all Americans want to do. So I thank you again, Dan, for being with you, and perhaps for having you here, and I hope maybe we can have a little bit more extended discussion about our interests. Thank you very much, ladies and gentlemen. And I think... For further information, please call Inside Law at area code 213-285-8599.